everyone, and thank you for joining us for another edition of our Justice and Peace's guest speaker series. Today we have a very special guest for us today. He is a bencher at the Law Society, so thank you very much, Robert Burd, for joining us. And perhaps maybe you can tell us a little bit about what the role of a bencher is at the Law Society and a little bit of your very lengthy practice experience.
Okay, so thank you again, John Paul, for the invite to speak to the students at Trios. I appreciate it. I think it's imperative, as the chair of the Paralegal Standing Committee, that we stay in contact with our licensing applicants. My role as a bencher, which is essentially, the term is meaning, director of the Law Society. My role is to assist in policy development. So the rules of conduct, which I'm sure you've covered in your ethics courses, are developed by two committees: the Professional Regulation Committee, which develops the rules and bylaws for lawyers, and then the Paralegal Standing Committee, which does the mirror rules for paralegals. So one of the functions we do is develop policy. Some of us, not all of us, but some of us are also adjudicators. So when there is disciplinary hearings, we sit in panels of three to adjudicate over misconduct hearings or good character hearings. That's essentially what we do, and we do such with the public interest in mind. I mean, obviously the Law Society's mandate is to regulate the legal professions in the public interest. And so although we're elected by our peers, we ultimately answer to the public, as the public is who we're there to protect. As far as my personal practice, I have been practicing now for way too long, over 25 plus years. My main practice is in municipal, provincial, and criminal law. Basically anything where it's the state versus the public. And I have a firm in Brampton, and I employ two other paralegals and two admin staff. So it's a small paralegal practice. The firm itself has been in existence since 1985, so it's a 35-year history. So I'm honored to now be the sole owner of that firm.
Thank you for that background. And now I know we're recently I think it's gone. The recent meeting that you had with the other benchers, there was some kind of talk about what are we going to do in light of, and I think it disproportionately affects paralegals, more so with the small claims court kind of being held back, and some of the tribunals, about licensees struggling financially through these times. And I think there was talk of this a motion about 25% cut, but that had to be tabled. So is there anything that you can shed some light on about fees and what's going to happen, as some of my students are going to get in and maybe paying those fees very soon?
Yeah, so absolutely. So obviously COVID is an unprecedented global pandemic that has hurt a lot of areas of, but more specifically in the legal profession, it has had a profound effect because many of the courts, tribunals have been closed, and some still remain closed or only partially administratively opened. So there has been a significant financial impact to all licensees, but heavily apparent for paralegals. So as such, months, maybe as early as late March, early April, the Law Society commenced what's called a program review, where we look at all of the programs that we provide licensees, whether they be internal or external, all of our funding, our budgets, so that we could find ways to save money and then ultimately pass that along to licensees. So we did have a preliminary motion to give 25% across the board, which, so for paralegals in the 2020 year, they paid just about $1,200. So a 25% savings would be $300. And so that was the original motion that was put forth, but it was tabled, which means it was postponed, simply because for two reasons. One is we have yet to finish the program review to see how much money we can actually save. So obviously, from a financial standpoint, we needed to find out how much money we can save, thus how much money can then be put to savings to licensees. And the other issue that became apparent was, do we do it 25% across the board, where you have some big Bay Street law firms that don't really need that relief? They haven't been impacted nearly as much or at all from COVID, versus souls and small practitioners that have really gotten hurt. So there was this idea of, and I know that they've changed the wording of it, but for our discussion, the hardship fund, which would be a definition of what hardship would be. And then, so you don't have to make an application per se, as like describing your financials. You would simply say that you meet the criteria of hardship, and then you would be eligible for that relief, which would probably be even more than the 25% that was originally proposed. So there is a segment of convocation, which is the collective uh, directors, some that felt, let's just do 25% across the board. It's simple, it's easy, and it's fair and equitable. And then there's others that have said, let's do this hardship fund, because we really should be assisting those that really need the assistance, and not the big firms or government employees, which have been getting paid their full salary and get their licensing fees paid by the government. So that's where we're at right now. So there's um, the Audit and Finance Committee, which is chaired by Joe Groya, and they are now looking at all of those options. So there will be relief for all licensees or there will be relief in 2021. Um, how much and who will it be for exactly has yet to be determined, but there will be relief coming.
Now, are the licensing fees, I mean, I know with the exception of if you're not practicing or you're fully not practicing, are they a set fees for lawyers and for paralegals, or is there something tied to, annual revenue or anything like that?
Yeah, so lawyer fees are set standard fees, and they pay more because of other, like they be for members for FOLA and things of that nature, right? So they pay a higher annual fees than do paralegals, but all lawyer fees are the same, and all paralegal fees. So it's not based on your income. It's not based on your jurisdiction of where your practice is. So all lawyers pay the same amount, and all paralegals pay the same amount.
Now, in the paralegal standing committee that you're the chair of, what are some of the hot button issues that are on the table for perhaps expanding the scope of paralegal practice? And certainly, we've heard a lot about family law potentially being on the table. So maybe you can give us a quick synopsis of what's coming forward.
Yeah, there's really three things that are on the go right now that are hot topic issues. One is criminal law, simply because in 2019, Bill C-75 was introduced, which changed the classification of criminal offenses, taking away the summary offenses, which were 6 months or less of incarceration, and moved them all to 2 years, which then ultimately, by virtue of that, expanded the scope of criminal practice for paralegals. And as a result of that, the our discussions with the Attorney General, it resolved that paralegals will continue to do the same scope that they had, with the condition that we would review the education that is equipped, that the community colleges and accredited colleges give the students in criminal law, plus other options that we could look at CPDs and things of that nature. So that's one of the topics that is sort of on the tail end of the expansion of scope. The other two are immigration. Right now, paralegals are permitted to do the appearances before the Immigration and Refugee Board, but are prohibited from doing applications, and are thus required to also become an immigration consultant in order to do full scope. The prohibiting factors there are obviously the provincial regulator, the Law Society, with bylaw 4. And there's also the immigration consultants that are the federal regulatory body for that area. As we all, or as many of you know, lawyers, by virtue of being called to the bar in Ontario, are permitted full scope in immigration. But paralegals and immigration consultants have to fulfill the requirements for an immigration license, which is now being switched to be a 2-year program at Queen's University that requires an undergraduate's degree. So that has, by virtue of that change, has made this a very hot topic. And in fact, there have been 2 applications to the Superior Court that have been filed challenging the jurisdiction of the Law Society to regulate paralegals in a federal statute for immigration. So those are, that is the second hot topic. And then finally, the third, which is a complete expansion, is the family law license. This is 4 years in the making. We have been looking at all facets and all areas pertaining to the family law license, and we now have released, it's been released for a while now, and is coming to a close in the end of November, a consultation paper which proposes a new license that would be in addition to your P1 license, that would permit a pretty progressive scope in family law. So we're hoping that we get the public to respond, licensees and licensing candidates to respond. As you can see from the consultation report, there's a proposed, the proposed license involves an 8-month full-time program or a 1-year part-time program. Who will administer that program is yet to be determined. That's part of the consultation. But what is defined is the core competencies that are required in order to do the scope that has been outlined in the report. It is progressive. It includes advocacy, which was originally not on the table, but we felt that just form filling would not be enough to make an impact. We looked at other jurisdictions. For example, Washington State implemented a paralegal program where they would assist the public in form filling, on family court matters. The uptake there was not that great, simply because, in my opinion, that wasn't enough. I mean, people don't want only part of the job done. They prefer to have the whole complete job done, which is not only the preparation of applications, but also the advocacy of those applications in family law court. So as a result of that, the proposed expansion is progressive in that it includes advocacy. And those are the three very hot topics.
Now, on all 3 of those topics, again, there's the thread there that perhaps is a challenge for you and your colleagues who are the paralegal benchers. Is what is the position there, or how is it difficult with potentially lawyers and groups like the Canadian Bar Association, the Ontario Bar Association, advocating maybe for paralegals not necessarily to get further scope in those areas. So how is the challenge there, since you're outnumbered at convocation, of getting that message across that we need paralegals in these areas, um, that they are not being able to represent currently?
Yeah, well, there are a lot of lawyer colleagues and lay bencher colleagues. So I should start by stating that convocation is made up of 40 elected lawyers uh, that are jurisdictionally balanced. And then there are 8 lay benchers, which are appointed members of the public by the government, and then the 5 paralegal benchers. So, in that standpoint, when you look at it, it looks like we're definitely outnumbered. But I mean, a bencher's responsibilities and their fiduciary duties is to regulate the profession in the public interest. And so many benchers, both lawyer, paralegal, and lay for that matter, get that. And they understand that even though they may be elected, they still have to put on their bencher hat and make decisions that are not self serving, but in the public interest. And so those that understand that realize that when there is an unmet legal need, and what your definition is of an unmet legal need is up for interpretation. But when there is cited an unmet legal need, then those benchers recognize that, and they acknowledge that paralegals have played a paramount role in access to justice, not only since regulation but even prior to regulation. So a lot of them identify that and acknowledge that, but we also do appreciate those that have issues, that have concerns, and the paralegal benchers, along with those that are sympathetic to the paralegal cause, have taken the opportunity to speak to those benchers, find out what their concerns are, and then we've crafted the consultation report to hopefully answer all of those questions, but also elicit more questions that, say, the Canadian Bar Association, the Ontario Bar Association, the Family Law Bar would have, and the concerns that they have. Because in order to get buy in, we need to be able to say that we have listened to all of the issues and we've addressed them. And so when you look at the consultation report, it's pretty extensive as far as the homework that we have done. Who created the scope, surprisingly, was well, there were paralegals involved, but there were subject matter experts. There was 5 family law lawyers and 2 family law clerks that basically said, well, if you do A, you need to do B, and so forth. So the scope was built in that manner, which gives me comfort that it wasn't self-serving and created by paralegals. This was created by subject matter experts who said you need to be able to do all of this in order to properly represent a member of the public. And so when you have them really look at it in its totality, the questions that have been asked about, competency, skill, affordability, all of those questions we've hopefully been able to address in the consultation report, so that we're not trying to silence our objector. We're trying to work with them to say we've heard them, and we've developed a license that we think will meet all of their concerns.
Now, I know that consultation deadline is coming up next month. What are the next steps beyond that? I mean, are we looking at a potential start from whichever provider sometime like September 2021 with graduates the following year, or is it going to be something that's like 3 to 5 years out from now?
Yeah, well, yeah, it really depends on how the responses we get back, and we've asked our stakeholders to be constructive. So, you know, we don't want responses that just say this is a terrible idea and not explain why and not be constructive. So first and foremost, we hope that the there's a lot of buy-in, and if there's not buy-in, that there's something constructive so that we can keep what is proposed as close to the proposal as possible. Then after that point in time, there will be an offer put out for the various different educators, whether they be law schools or the accredited colleges, for the law society, for the paralegal program, to help work with the law society in developing a curriculum that covers the core competencies that were outlined by the subject matter experts. So once that has been done and there's been somebody awarded that contract per se, um, uh, then it is the implementation, and then we start the rollout. So that doesn't seem like a lot to do, but in fact, it it would probably take us at least till the end of 2021, where there won't be the first class going until 2022. I would probably predict.
And the other areas you mentioned, so immigration, and certainly you mentioned a couple of applications there. In terms of that, maybe you can clarify. Is it simply bylaw 4 that is kind of limiting the work of paralegals in form filling, for example, with respect to, let's say, spousal sponsorship applications and a host of other ones? Or is there more moving parts than simply, the law society waving a wand and saying, okay, bylaw 4 has changed, we're not going to restrict paralegals?
Yeah. So the way it currently was working was a P1 licensee could appear before the IRB, but was prohibited from doing any of the forms, the application forms for full scope. And as a result, they had to become immigration consultants in order to do full scope, which means carrying two licenses, paying two insurances, which is, you know, in today's time especially, quite a barrier. Um, but then what's happened now is the federal government has created yet another federal regulatory body for immigration. And I'm not 100% sure of what their acronym is. It used to be ICRIC, which stands for the Canadian Immigration Consultants. But they have now instituted that anyone moving forward will need to do a 2-year program at Queen's University with an undergraduate's degree as a prerequisite. That throws in even more barriers for paralegals. So as a result of that, the Law Society has had started communication with the federal government, stakeholders like the CBA and the immigration consultant regulatory body, to work out something so that paralegals or paralegal licensees would be exempt from undergraduate's degree and things like that, because we looked at what the core competencies were of that 2-year Queen's program and realized that the paralegal programs that were offered at various different accredited colleges covered about 65 to 70% of the material for core competencies. So there is the question about where will the licensing candidates get that other 20 to 30% that's still required, that's not being taught. That becomes one of the issues. So it is a trifecta between the federal government, the federal regulator, and the provincial regulator, and deciding what is the best course of action that protects the public. Um, and in doing so, it isn't as easy as what some may have reported or some may believe, that all the Law Society has to do is, as you said, JP, and wave their magic wand and get rid of bylaw 4, which is what the restricted thing prohibits them from full scope. That was instituted in negotiations with the federal government and the immigration consultants, and that's when it was created way back when. So for us to unilaterally change something that was negotiated has to be renegotiated for that to happen. And so there's a lot of moving parts that have to be ironed out. There's a lot of politicking that happens when you make something like this that is so significant in creating an expanded scope. And then getting back to what we talked about earlier, you have those that don't believe that paralegal scope should be expanded. So you have the Canadian Bar Association, who's already on record saying that they don't agree to this, which would also thus mean that the Ontario Bar Association would also not be in favor of it as well. But so when you have that, and those organizations wave a pretty big stick and are fairly influential, so you don't want to. Not that we're not prepared to put up a fight and fight for paralegals, but you want to be careful because you you might regret what you asked for because you might get nothing at it in the end. And so we are very cognizant of how negotiations are going. We have a team at the Law Society of our government relations that are actively in contact with all of the parties that I mentioned. And discussions look positive. So we're hoping to come to some conclusion in regards to immigration in the next few months.
Now I see a question from Adam here, looking at maybe it's time to revisit sort of the way paralegal education is, and I know we discussed earlier about uh, maybe we're looking at electives, or let's say areas of focus, right? Because uh, I mean, I have plenty of students who I've taught over the years, and some of them come in and they go and practice in landlord tenant. Some of them practice in provincial offenses, small claims court. I mean, there's so many different tribunals you can focus on. But after the initial sort of core courses and or all the mandatory courses, uh, there isn't necessarily something afterwards that they can. I mean, certainly they can do continuing professional development and programs of that sort. But is that maybe something that's on the radar for the Law Society, is creating maybe a sort of a POA certificate or criminal certificate that are added to uh, the existing sort of accredited programs? That way you can address that 35 or 25% gap and offer it, rather than paralegals going and becoming dual licensed through the ICCRC or I think it's the Canadian College of Immigration Consultants down the road.
Yeah. So I mean, obviously, the first example of that is the family law license. That proposal is out. So it would be in addition to your P1 license, right? So not all P1s. So if you have no intention of doing family law, you don't have to take it. Um, but for those that wanted to, they could, which would then make them um, an F1 license holder, for lack of a better term. And we are looking at alternatives like that, as I said, in the areas where we have recently expanded. So in criminal law and in immigration. So just like you said, JP, some of the deficiencies that are not there, that aren't being covered for full scope in immigration, how do we fill that gap? Do we do it with mandatory CPD programs? Do we do it with extra electives that people could take? Um, there's a variety of ways that we're looking at how that could be established, and so that the Law Society fulfills its mandate, that making sure the core competencies are there so that the public is protected, and also give the confidence to the licensees that they can start practicing in that area. Because one of the things we noticed is in criminal law, very few paralegals practice it. So each year, we lawyers and paralegals are required to do an annual report. That gives the Law Society statistics as to what areas of practice and things people are doing. And in regards to paralegals, the criminal law practice is um, not non-existent, but proportionately it's very low. And so we wonder why. Is it because of the intimidation? Is it because of the lack of fulsome education? So we're trying to identify what the issues are, because just to permit somebody to say you can do it obviously has shown, in criminal law at least, that it doesn't mean that they will do it. So we have to go back and see what those blocks are that are preventing paralegals from practicing in those areas. So once we sort through that, we will have a better understanding, and we can ensure, for example, those that get the family law license will not only be confident and competent to do the work, but they'll have all of the training that is necessary for them to do the work, so that we are confident that the public will be protected. And we need to figure that out for immigration and for criminal law.
Now, maybe you could share. There's been a few big gains there for paralegals, especially during COVID now, with respect to commissioning and notarizing documents. So, can you perhaps share what paralegals are now allowed to do with respect to those areas?
Yeah. So, well, further back in time, there's three developments that have really happened. So you mentioned two of them. So one is that you are a commissioner of oaths. By virtue of being licensed, you become a commissioner of oaths. Further, after that, in a recent budget bill, the Ontario government also acknowledged that paralegals are now officers of the court. And then most recently, again, the Attorney General instituted that changes to the Notaries Act that also now included paralegals. So for the Notary Act, you just have to simply apply. I haven't heard anybody who is yet to be denied being a notary, but as a paralegal now, you are eligible to become a notary. So those are three very lofty achievements that have occurred during my tenure as a venture at the Law Society.
Now, one of the big reasons for the development of licensed paralegals is access to justice, right? And filling in gaps where either people could not afford to pay the lawyer's fees or things of that nature. Now, could you maybe share some of, I know there's something coming up at the Law Society with respect to Access to Justice Week. Perhaps when you could share some other initiatives focusing on access to justice itself.
So access to justice isn't just, it's not a paralegal thing. There are a lot of initiatives that have been implemented to assist the public where we find that there are unmet legal needs. There's been a lot of projects like the civil, unmet civil needs that was done to assess, and I have to give credit to Doug Downey, our current Attorney General. He has really taken a lot of strides in order to facilitate access to justice. So access to justice is also including things such as technology. So at the Law Society, for example, as part of our Access to Justice Week, we have a technology committee that looks at advancements as to how we can better utilize technology in application preparation, filing applications, which is, the old-fashioned way of hand delivery is very non-COVID friendly. So things like that, but also other initiatives such as unbundling of legal services, where the Law Society changed our rules to permit licensees to afford the public the ability to represent them in only a portion of their legal need rather than the entire start to finish. These are all sorts of initiatives that generate through Access to Justice Committee and the Access to Justice Week that the Law Society co-hosts to look at avenues and have discussions about what can be done to improve access to justice, because legal fees are the number one barrier for access to justice. And so if we can look at ways to reduce fees and to educate the public, that assists them greater access. And that's really what the role the Law Society plays. So whether it be online programs, online websites, online education, we are looking at a whole different variety of alternatives to help facilitate access to justice. And the Access to Justice Week helps highlight that. So there's invitation that licensees and the public can come and hear about the initiatives that the Law Society, in their partnership with other stakeholders are commencing for access to justice.
Now, in your, I think this is your third term there. What have you seen in terms of development, whether around access to justice or certainly you've highlighted a number of improvements for paralegals. But what can you look back on and saying, look at what we've accomplished, and what would you say for someone who would be running for bencher in the future? There, of what areas can they further improve on besides the three we highlighted with respect to immigration, criminal law, and
Yeah,
family law?
if you want to talk about it more from a personal perspective, believe it or not, when I was first elected, I was instructed not to speak at convocation. So paralegals were back then, and this is only March of 2010, we were considered second-class um, citizens in some regard. And so one of the things that I'm most proud of is twofold that I directly played a part in. Not only is that paralegals are now accepted as active members, benchers, and board of directors of the Law Society, many of us hold leadership roles, whether it be chairs or vice chairs of committees, which says a lot to our current treasurer who um, empowers us with those leadership roles. But when we look at some of the initiatives the Law Society has done in recent years that I played a part in, one was the challenges facing racialized licensee working group, where we came up with recommendations to help facilitate the racialized licensees in their challenges in the delivery of legal services and their treatment within the legal profession. So a lot was done there. And then I also was involved in the Indigenous Review Panel, where we looked at the Law Society's relationship with the Indigenous community and the hardship that Indigenous people have endured, and how the Law Society has or has not helped in assisting them in their legal issues. So those are, things that you don't really hear about as a licensee so much, but are really, from a personal standpoint, significant changes in the attitude that the Law Society had in recognizing that there are differences, there are challenges for various different licensees and various different members of the public that needed to be acknowledged and recommendations put forth to facilitate change. So that is two things that I've been, very proud of. But then, in the earlier years, the paralegals were like mouses. Like, you very rarely heard from us. Now, if you watch convocation, or if you ever were to attend a committee meeting, which the public aren't permitted to, but I'm very proud of the five, the other four paralegal benchers. They are very vocal. They, are champions for not only for paralegals, but also for the public. Because in my view, and this is only my view, paralegals better relate to the public and the challenges the public faces. So those are kind of like the summary of things that I'm most proud of achievements that the Law Society has done from a personal standpoint.
I see another question here from one of my students, Adam, here. Essentially, what can the Law Society do for those who are self-represented, right? I mean, in terms of not having access, obviously, to quality representation, maybe not through affording lawyers' fees or paralegals' fees for that matter, but what can the LSO do to improve the overall quality for those who are self-representing? What other tools can be offered?
Yeah, so some of the things that we do offer the Law Society, number one is our website has a vast amount of information for self-represented parties, and or links to government websites that also have an additional amount of information for self-representatives, the how to do type of things. But one of the other things that we do that actually helps promote licensees as well is the Law Society referral service. So it affords the public a half-hour free consultation with a lawyer or paralegal in the area of the concern that that member of the public has. So we not only give them vast amount of information on how to do it on your own, but even if there is a need for them to um, consult with a licensee, the Law Society facilitates that through the Law Society referral program, and gives the public that half-hour free consultation as well.
Now, you also touched on equality, diversity, inclusion, and the strides that have happened there. What I think, and perhaps maybe you have these numbers from the annual reports, but I mean, I look at the demographics of my classes, and they vastly differ from my law school classes of 12 years ago. Do you see a trend with respect to paralegals versus lawyers, or certainly just maybe within paralegals that you're seeing people from various different backgrounds along those the lines of equality, diversity, and inclusion in terms of paralegals coming into the profession?
Yeah, and that actually, I should have included that as part of my one of the proud moments. So paralegals, the makeup of paralegals is very much in line with the Ontario public and the makeup of the Ontario public, in that um, almost 60% of all licensees are female and 40% of all licensees are racialized. So that is, which are greater percentages than our lawyer colleagues. Um, and that's why it was extremely important that the Law Society make changes that were recommended by the racialized working group, because you have a lot of NCA candidates that are coming from other countries, and the Ontario public feel comfortable dealing with people from their own cultural or ethnical background, so that they, because sometimes English isn't their number one language, they want to speak to somebody in their mother tongue, so that they feel comfortable in that. And so we wanted to reduce the barriers so that licensees from all over can facilitate and have viable practices, so that the public can be properly represented on their counsel or paralegal of choice.
Now, I know you have a lot of experience in adjudicating matters at the Law Society Tribunal. Uh, Perhaps you can share with my students, so they never appear before you there, what are some of the things to avoid, or the mistakes that you've seen, whether on good character issues or with respect to professional misconduct? What are the biggest challenges and mistakes that recent graduates and new practitioners find themselves in trouble with before the Law Society?
Right. So the first and foremost is the good character. So good character hearings are mandated by virtue of how you respond to your licensing application. If you have had a unsavory past, say you've been charged with criminal or convicted of criminal offenses or things of that nature, suspended from organizations or what have you, that may trigger a good character hearing. Simply the threshold there is that you have to prove beyond by virtue of balance of probabilities that you are currently of good character. And the precedent for that case is the Law Society of Upper Canada versus Armstrong, which highlights the what we call the Armstrong factors, right? So everything about rehabilitation, remorse, how long ago the transgressions were, and things like that. So that's pretty standard. But after you become licensed, what we find, and this has been through the research that we've done, is that soles and smalls tend to get into trouble more so than those in big firms. Now, naturally, why is that? Because there's the support groups. There's more people for a licensee in a big firm to get, an accounting department or things of that nature. So the main issues that we see complaints about are failing to respond. So that failing to respond could be to the client or to the law society. And but the one that puts your license in greatest jeopardy is anything to do with fraudulent behavior or misapprehension of or a misallocation of trust funds and things of that nature. So if you ever are in doubt as to what procedure to take or what method to use, we have the practice helpline, practice management helpline at the Law Society, and we also have the coach and advisory network. So for licensees, if they are in uncertain as to how to proceed, we have those practice benefits for you. But even more importantly is some of the cases that we get in discipline are a derivative of someone's mental health. And the Law Society, which affords licensees and paralegal students, in fact, used to what's called the Membership Assistance Program, the short form acronym of MAP, which gives you independent, confidential counseling on any issue that you may have, whether it be mental health issues, even financial hardship and things of that nature. So, and it's completely independent of the Law Society and it's confidential. So these are steps and measures that are taken to hopefully prevent licensees from ever coming before me in a discipline or misconduct application.
Just looking at the time there, is there any questions from any of the students? I know you've been writing them there, so if anyone hasn't had a chance to ask something, just pop it into the chat box there and I can relay it to Robert Burd here. And thank you again for joining us today and speaking to both of the classes in the morning and the evening. So
yeah, I do want to say to the student body that, don't be shy about asking a question. This is why I'm here. That's why I've agreed to come here today, because I think it's, even myself, when I first got licensed, I was really intimidated by the Law Society. The Law Society, getting an envelope with the Law Society emblem on it was always nerve-wracking, right? And I'm trying to do as many public speaking engagements as I can to lessen that fear that licensees have and licensing applicants have of who the Law Society is and what they are. As the chair of the Paralegal Standing Committee, it's imperative for me to make sure I'm in touch with licensees and licensing candidates to find out what the challenges are. And so if you have a question or you have a concern, I don't want it to go unanswered. So it's best that you, either speak to me personally or in these types of forums, get your questions out so that they can be answered.
So I see there's a question coming from Bryce here. So Bryce, if you want to just unmute yourself and ask away.
Hello. I'm unmuted, right?
Yes, you are.
Okay, great, perfect. Sorry. I'm curious as to if you have any specific challenges related to the disparity between population of North and South of Ontario. You mentioned Aboriginal and access to justice in that sense, but I'm just curious if you're currently running any programs for access to justice for communities that might not be marginalized because of their sort of culture, but more so because of population or lack of actual physical paralegals or lawyers in general.
Yeah, so that's a great question, Bryce, and thank you for that. So one of the tasks of our technology task force is to look at ways of providing that sort of assistance to outreach communities that are difficult to come by. There is some very, very preliminary discussions about accrediting a college in Thunder Bay for paralegals. As some of you may know, in recent years, within the last decade, there was a law school that was opened in Thunder Bay as well. And we're hoping to do the same for paralegals as well, or have a college there for a paralegal program, so that remote communities in Northern Ontario can have a school where they don't have to travel so far. One of the good things about COVID was it really accelerated that type of thought, and us doing online or permitting online teaching and online licensing exams has facilitated that. So now, regardless of what part of Ontario you are in, you can participate in a college program and ultimately then also get licensed all in the comforts of your home. So those types of changes have made an impact. But as I said, the technology task force that we have is looking at even greater things that can be done to facilitate and access to justice in the northern parts of Ontario, which are admittedly unrepresented. So when we look at our annual reports and we find out where paralegals are located and where lawyers are located, there are for the population, it's unrepresented proportionately. So obviously we need to address that.
Thank you very much.
No problem. Great question.
See another question about maybe you can share. We were talking about Access to Justice Week, but someone's asking about what are some maybe podcasts or some professional development or maybe just some initiatives in general geared towards future paralegals and maybe organizations that put on some of those events. So specifically to paralegals, I know there's a lot of CPDs. I mean, I have to go for my CPDs, but what are some ones maybe you can highlight that are geared towards paralegals specifically for the law society?
So the Law Society through our CPD has a lot of programs, and many of them are paralegal related. I know I myself am doing one in November and another one in March. And the one in November is about your practice during COVID, right? How to make adjustments to your practice during COVID. So the Law Society provides both paid and free programming that are programs that are specifically geared towards paralegals. So I invite everybody to go on the Law Society website, which is www.lso.ca, and you can research the CPD programs. And then there are, for example, there is the Ontario Paralegal Association, which is, sort of like the equivalent of the OBA, and they do annual CPD. When you become a member, they have discounts for students. So membership there is less for a student, and then it comes with all the free education and CPD that you need. Just so that everyone is aware, one of the requirements upon being licensed is that every year you complete 12 hours of continuing professional development. And of those 12, 9 have to be on substantive and 3 have to be professional. And then within the period of 3 years, there has to be 3 years of equity, diversity, and inclusion courses that you take. So there is an obligation. So, even after your program and you're writing your licensing exam, your education never ceases to end. You're always constantly keeping yourself educated, which helps with our mandate to ensure that the public protection is there in the delivery of legal services. So you are obligated. There's a lot of great resources, and the Law Society, because of COVID and the challenges, have either reduced the cost or put a lot of the programs free.
All right, so if there's, I guess here I can tie this question from Rochelle here maybe to a final question of, she's asking, what advice would you give to your younger self? So maybe I take it a step further, and what advice can you give to I mean, I know back, in the 1980s, there was no licensing requirement. But if for my students who are just ready to enter into the profession, what kind of advice could you offer them from getting through the rest of the program, especially in light of COVID-19, and getting into being licensed paralegals and succeeding in the profession? So maybe you can address it from your younger self first, and then everyone here that's love listening to you.
Yeah, so I mean, I can tie it all in together. Basically, what I would have said to myself and what I would say to licensing students now is when you, for example, when you go for your placement and you're only required by your college to do 120 or 140 hours in order to get licensed, but there is nothing preventing you from doing more. And when you have a mentor, like another fellow licensee that's experienced, whether they be a lawyer licensee or a paralegal licensee, that is, an unlimited source of education and knowledge that you should take advantage of. So when my younger self, um, I would say, keep your ears open, listen as much as you possibly can, absorb as much as you possibly can. And I would also say don't rely solely on the education that you received at your college. I mean, there's a reason why we have the requirement for annual CPD. It's because we challenge licensees to keep themselves learning on a day-to-day basis. And so any opportunity you can capitalize on obtaining a mentor, I certainly would. If you find that difficult, the Law Society has the, which is called CAN, which is the Coach and Advisory Network, where we will pair you up with a mentor in any area that you are seeking advice on. So there's a lot of resources like that I would say that people unfortunately aren't taking full advantage of. Like I have an iPhone 8. I don't even know 50% of the functions that it's capable of doing. And the same goes with licensees. They don't realize all of the management, the resources that the Law Society has available to them that you can take advantage of. And so the first thing I would do is research what programs can I take advantage of and utilize to my own benefit. And then when I get a mentor, whether it be through my placement or through the Law Society, take full advantage of it. And don't just say after the 120 hours, I'm out of here. Stay longer if you can afford to do so, because that's where you tap into the knowledge that you're going to ultimately need to have a successful practice. The other thing I would say is this: if you are interested in going into Provincial Offences Act, I would not suggest that you go to a Provincial Offences Act practitioner and say, can you hire me? I would go to a small claims court specialist and say to them, hey, how about expanding your scope by including me in your practice, and we can start doing POA matters, for example. Because what we see in the role model of lawyers is successful law firms cover all areas of practice, whereas paralegal firms seem to be specialized. So you'll have a traffic ticket paralegal firm, you'll have a small claims paralegal firm, you'll have a landlord-tenant paralegal firm, but you very rarely see those multidisciplinary practices. And that's what the difference between law firms and paralegal firms is. They don't provide the public that all-encompassing scope. So I would suggest to you as new licensees that I would look to pair myself up with somebody that does a practice in another area and share office, rent office space together collectively to keep costs down at the beginning, so that it is more probable that you'll become successful quicker.
Perfect. So thank you so much, Mr. Burd, for taking the time and talking to, again, both my morning and evening students here.
Yeah.
Really appreciate it. It gives a lot of different perspective. It's where you get a chance to have dialogue with, some of the benchers, and I think we've been fortunate enough to have. I think next month we'll have Shalina as well, which would be the fifth and final one. So different perspectives. It's really interesting seeing how all of you've got into your roles there and have succeeded both in your practice and in terms of advocating successfully for a lot of things that you've highlighted, and will hopefully continue to advocate with respect to family law, immigration, and criminal law as well. So thank you again for joining us, and we wish you all the best in your continued pursuit.
Thank you so much. And if anybody has any questions, feel free to send them on to JP, and he will pass them on to me, and then I'll be sure to answer any questions that went unanswered. Thank you all very much.
Thank you.
Take care, Mr. Burd.
I'm actually really interested in talking to him about that demographic data. And